California has a balanced budget requirement. The short answer to the question of whether the state is required to adopt a balanced budget is yes, but there are a couple of interesting aspects associated with this balanced budget requirement. So, existing provisions of the California Constitution were interpreted to require a balanced budget. For example, Article 4, Section 12A requires the governor to submit a budget by January 10th, and if recommended expenditures exceed estimated revenues, the governor shall recommend the source from which the additional revenues should be provided. This constitutional provision was deemed to at least require the governor to submit a balanced budget. In addition, in Article 26, Section 1, it limits the legislature's ability to incur debt of more than $300,000 unless the legislature passes by a two-thirds vote a measure that's adopted by the voters. This constitutional provision was deemed to preclude the legislature from adopting a budget that would create a debt or a liability in excess of $300,000 to the state. Since 1983, Government Code Section 13337.5 requires a balanced budget. This statute provides the Annual Budget Act shall not provide for projected expenditures in excess of projected revenues. Further, it is the intention of the legislature that in the event, after enactment of the Budget Act, revised estimates of expected revenues or expenditures or both show that expenditures will exceed estimated revenues, then expenditures should be reduced or revenues increased or both to ensure that actual expenditures do not exceed actual revenues for that fiscal year. This issue was finally settled with an amendment to Article 4, Section 12, when subdivision G was added, and it says that for the 2004-5 fiscal year or any subsequent fiscal year, the legislature may not send to the governor for consideration, nor may the governor sign into law a budget bill that would appropriate from the general fund for that fiscal year a total amount that, when combined with all appropriations from the general fund for that fiscal year, and the amount of any general fund monies transferred to the budget stabilization account for that fiscal year, would exceed the general fund revenues for that fiscal year, estimated as of the date of the budget bill's passage. And the estimate of general fund revenues is required to be set forth in the budget bill as passed by the legislature. So now the balanced budget requirement is a constitutional mandate that applies equally to both the legislative and executive branches of government. So the governor must submit a balanced budget to the legislature, and the legislature must pass a balanced budget to the governor. So how is the notion of balance determined, and who gets to decide if the budget is actually balanced? Well, per the California State Constitution and an appellate court decision, that determination is made based upon what's contained in the budget bill. In other words, the budget bill contains both the expenditure listing as well as an estimated amount of revenues for the forthcoming fiscal year upon which that budget bill is based. That means that the determination is up to the legislative and executive branches of government. And this was confirmed by the California Court of Appeal in the third district. The case is Steinberg versus Chung. It was issued in 2014. And the previous state controller at the time argued that in his audit capacity, he could determine whether the state budget was balanced. And he said that for purposes of the 2011 state budget, it was not balanced when the legislature sent that budget bill to the governor. Now, the appellate court for the third DCA unanimously disagreed with the perspective of the controller. The trial court and then the appellate court both concluded that the legislature complies with the constitutional provision for a balanced budget when the legislature enacts a budget bill in which its revenue estimate for the coming fiscal year would exceed the total of existing appropriations for the fiscal year. plus any new appropriations proposed for the budget bill and any transfers from a reserve fund. At that point, the controller does not have the authority to make an independent assessment that the budget is or is not in fact balanced, because the budget bill relies on revenues that may not have been authorized. And that is what the controller argued. So in this case, in Steinberg versus Chung, the legislature successfully sought and got a court declaration that the legislature complies with the balanced budget requirement of the state constitution when the legislature passes the budget bill, in which all appropriations, including monies transferred, etc., do not exceed the legislature's estimate of revenues to be received. So it's the legislature that sets forth the revenue estimate in the state budget bill. And that estimate will essentially not be subject to review by any other constitutional officer or a court. In fact, the appellate court specifically found in this case of Steinberg versus Chung that the controller cannot second guess any revenue estimates. In addition, the court ruled that the state constitution does not require budget trailer bills to be enrolled and sent to the governor for signature before the constitutional deadline of June 15th. The appellate court also expressly addressed the issue of estimates on the receipt of federal funds, and it said, indeed, the controller overlooks the extent to which California balances its budget with federal funds, the authorization for which is entirely outside the control of the legislature. Hence, even though the controller alleged that there might have been phantom revenues in the budget bill's estimate, the appellate court said that it would amount to inappropriate judicial interference with the prerogatives of a coordinate branch of state government to endorse the controller's intrusion into the budget process. The court then addressed the obvious question as to how to enforce the balanced budget requirement. And the court ruled that the governor can enforce it either through vetoing the budget as a whole or exercising the governor's line item veto authority. So it's essentially the legislature that enacts what it designates to be a balanced budget, with the check from the governor through the governor's use of the line item veto authority or blue pencil rule. It also means that the legislature can adopt a balanced budget based upon its determination that federal funds or new revenues might be forthcoming, even though there's no guarantee of receipt of those federal funds.